We are back and thrilled to be with you, digging into the scourge of big money in politics. Lisa Graves, Alex Aronson here with Court Accountability Action and Legal AF. Thrilled to be with you. And we could not be joined by any better guest than our friend and partner, John Bonifaz, the co-founder and president of Free Speech for People. And John, you're a constitutional lawyer, a really good one at that. And you've been at this for a while. You founded Free Speech for People, you just shared, on the day of the Citizens United decision. And you've been really pushing the envelope on these issues ever since, not letting up on the gas in terms of trying to get to these root causes of this breakdown of our democratic process and the corrupting influence it has allowed to unleash across the country, very much resulting in this ugly state of affairs that we find ourselves in. And yet you're not just sort of calling attention to the problem, but you're advancing affirmative solutions to reform. And we wanted to dig into some of them today, which are active in the states, at the municipal level, in the Congress, and of course also in the courts. And we just had a ruling from the District of Minnesota, a Trump judge, about a policy you were instrumental in helping to pass in Minnesota, trying to succeeding in banning foreign investment corporations from participating in electoral politics. Could you break down sort of what that policy is, what that means, and maybe tee up a conversation about this case?
Yes, absolutely. Thanks for having me, Alex and Lisa. Great to be with you. So this policy is designed to end foreign influence corporate spending in our elections. As we may remember, then President Obama, right after the Citizens United ruling in his State of the Union address, chastised the Supreme Court for that ruling and said it would lead to foreign interference in our elections. And Justice Alito famously broke decorum, shook his head, and mouthed the words, "not true." Well, in fact, we know that President Obama's prediction was proven to be true, not just with the Russian interference in our elections in 2016 and beyond, but the way in which foreign investors can now subvert existing federal law through the corporate form. Existing federal law bars foreign nationals from spending money directly or indirectly in our elections. It's the only area of federal campaign finance law that applies to states and localities as well. So no one who's a foreign national is allowed to spend any money, a cent, a dime, in any election, federal, state, or local. But foreign investors can subvert that law through the corporate form as a result of this loophole created by the Citizens United ruling. And so what this policy does is it says that foreign influence corporations must also be prohibited so as to preserve American self-government. It's worth noting that a Canadian citizen challenged this federal law and that has been on the books for some time now. And then Judge Kavanaugh, the DC Circuit, wrote the opinion for the 3-judge District of Columbia panel upholding the law on the grounds that it preserved American self-government. And the Supreme Court upheld that opinion in Blumen v. FEC 2 years after Citizens United. So applying the principles of Blumen v. FEC, this very policy is also constitutional. And Professors Lawrence Tribe and John Coates at Harvard Law, many other scholars have submitted testimony in support of it. But this district court judge, who, as you said, is a Trump appointee, a former corporate lawyer, found that it was invalid in this ruling last Friday, February 7th, on the grounds that there was not proof by the state of Minnesota that there was foreign control of these companies. Now, first of all, there was plenty of evidence demonstrating that the thresholds that were at stake here, 1% single stock ownership or 5% in the aggregate from foreign investors, that is a significant level of foreign influence in a corporation. In fact, 1% single stock owner, as we know, has the ability to introduce a shareholder resolution, get the CEO on the phone, and owns hundreds of millions of dollars of shares of a major Fortune 500 company. But this judge sets up this barrier that doesn't exist in campaign finance law, where you have to prove this kind of control in order to demonstrate that the law is constitutional, when in fact, as I said, not even a dime is allowed to be spent by foreign nationals under the existing federal law. So we think it's contrary to what the Blumen v. FEC holding found, both by Judge Kavanaugh at the time and by the Supreme Court. And this policy is advancing in many other states. The Hawaii State Senate is about to vote on it. Other states such as Washington State, California, Massachusetts, New York, Illinois are all considering it. And it's been introduced in Congress by Congressman Jamie Raskin and Senator Sheldon Whitehouse. So the fight is going to go on for this kind of policy because it's clear reform that we need to end multinational corporate spending that is such influenced by significant foreign investment.
That's such a clear answer, John, and it's so wonderful to be on this program with Legal AF with you and with Alex. I know from our work at the beginning, right before Citizens United came down, just how brilliant and how devoted you are to these reforms, John. So just want to thank you for your tremendous work over these many years. There are two things I just want to inject into the conversation. One is, we've learned since that Citizens United decision, that in fact, it never should have been a 5-4 decision because Clarence Thomas sat on that case, did not recuse himself, even though his wife had just received $500,000 from Harlan Crow to stake her C3 organization, Liberty Central, to take advantage of the decision to come. But the other thing that we've learned since then is that, and this goes to this foreign influence point, one of the things that happened, and I've been researching this for my book about John Roberts, one of the things that happened is that right after the U.S. Supreme Court issued the Heller decision, which was the decision that changed the interpretation of the Second Amendment for the District of Columbia and basically allowed people to carry, to have handguns in the District of Columbia. Right after that, the NRA received a donation from Beretta, from the U.S. subsidiary of Beretta, from the CEO, the heir to the Beretta fortune, an Italian man, $1 million after Heller in order to take up the Chicago versus McDonald case, in order to wipe out Chicago's handgun ban and basically fill the coffers of Beretta with cash from the sales of Beretta handguns. And, there's been no cry from the right about this sort of foreign influence. In fact, the litigation that just happened, the decision by that Trump judge this past week, would help facilitate even more influence by these corporations, U.S. subsidiaries or U.S. firms related to these foreign corporations or foreign CEOs to distort not just statutory law, but constitutional law, like Beretta did. I wonder if you have any thoughts about that, John.
Yes, Lisa. Well, first, we're honored to have you, as you have been for many years, on our advisory board. And it's great to be with you as well. I mean, look, I think what you're painting is clearly a picture of the kind of corruption that's so dangerous right now in our country with respect to big money in politics. But this question of foreign influence is particularly significant because, in fact, as we know, there's a different compelling governmental interest in protecting our elections and our government from this influence, and that is to preserve American self-government. It's separate and apart from the longstanding compelling interest of preventing corruption and the appearance of corruption. And I think that's really what your example goes to, and so many others. So look, Uber, it has a Saudi investment. Saudi Kingdom has a significant investment in Uber. So when they're spending their money, general treasury funds all across the country to try to stop regulation of their industry, that's infused with Saudi money. We know Airbnb has a Russian oligarch that's invested in it. We know that Amazon and Chevron have significant foreign investors. And, one former CEO of Exxon said famously that he doesn't have any allegiance to the United States, that he's got the allegiance to his shareholders, and his shareholders are all over the world. And that's the way these corporations work. And so after Citizens United, if corporations want to make expenditures in our elections, then they have to ensure, as Justice Kennedy said in Citizens United, that there are associations of citizens. And that's not what many of these multinational corporations are. They are at best a mixture of associations of citizens and foreign investors, and they should not be allowed to influence our elections because of that.
John, the parallels you raise between the way this Trump judge sort of erased the evidence of this type of foreign influence on the record in this case, and what the Supreme Court itself did in Citizens United, really wiping away this bipartisan consensus, these findings of fact about the potential for corrupting influence from unlimited independent expenditure seems striking. And here we have a judge who seems poised to effectively and in bad faith seemingly extend some of that constitutional manipulation from Citizens United into this completely different context, which also seems to have the effect of invalidating by implication all of those laws you mentioned that ban that ban foreign influence on our political system. So maybe you could break down like what would be the impact if this decision holds at the Eighth Circuit, if it becomes the law of the land at the Supreme Court. What does that mean for those underlying statutes that prohibit this type of foreign influence? And what does it mean for our political system if this continues?
I think it puts them in danger, clearly. Now, to be fair, we don't know what the Attorney General of Minnesota is going to do with this district court ruling and whether they're going to appeal. But I do think that it would put in danger many of these other laws around the country designed to block foreign influence when you have this kind of decision, perhaps going up to a higher level. I do think there's a real potential that there will be yet another state, whether it be Hawaii or elsewhere, that passes this model legislation and creates a different kind of test case and perhaps a different judicial review than what we saw out of this judge. To be clear, this was a ruling on motions for summary judgment. So there was no trial in this case. There was no full airing of the facts and the evidence demonstrating how foreign investors can subvert the corporate form. And all the more reason why it was wrong for this judge to have decided on the merits that this law is invalid without even hearing those facts at trial. But this goes to the other point about you're making here about Citizens United. It is categorically wrong to say that there is no reform now that can be enacted because of Citizens United, whether that be in this context dealing with foreign influence in our elections, or frankly, whether it be in the context of super PACs. It's commonly misunderstood that super PACs came directly from Citizens United. They did not. They came from a DC Circuit Court of Appeals ruling that wrongly read Citizens United as saying that because independent expenditures cannot corrupt, then unlimited donations to a PAC cannot corrupt. And it was never reviewed by the Supreme Court. That case was Speech Now v. FEC. And then Attorney General Eric Holder decided not to appeal it to the Supreme Court because he wrongly thought that it was only going to affect a small subset of federal PACs. Those were his exact words. So now we're facing this onslaught of the impact of super PAC spending in our elections, with the richest man in the world, Elon Musk, putting nearly $300 million to get his candidate, Donald Trump, elected. And this now is a clear danger as well, which is why it's so important what the state of Maine has just done. They've just passed with 74% of the vote, a widespread across the political spectrum kind of support, an initiative, a ballot initiative that effectively bans super PACs in their state elections, put those limits back in place of $5,000 to a PAC. And Larry Lessig, Professor Lawrence Lessig at Harvard Law School, is to be commended. He and his group, Equal Citizens, for helping to catalyze that ballot initiative, and all the groups in Maine for getting it passed. We strongly endorsed it and supported it, and we're now going to help defend it. It's been challenged by super PACs in federal court. We're going to represent Mainers for Working Families with an amicus brief, and we're going to fight to have Speech Now reviewed for the first time by a court in Maine and then by the First Circuit Court of Appeals. And there's a real opportunity here for a different court to look at this question 15 years later and decide whether unlimited donations to super PACs is corrupting or it's not.
I'm so glad you raised that, John, because that action in Maine, that bipartisan, transpartisan, nonpartisan, overwhelming, populist support for this reform, I think that could happen almost in any state if there could be organizing around it, because people hate this corruption. They hate this culture that the City United Court and that lower DC Circuit Court has allowed to take hold. And one of the things we've discovered, and that has been reported also, about the people who are trying to attack this new citizen effort, is that it's, of course, tied to Leonard Leo and his billionaire bucks that he got from billionaire Barry Side to basically try to keep as much money as possible in our elections, in our politics. And so we can trace out how he's tied to one of the main groups that is involved in attacking this law. But I'm so glad to hear about the efforts to take this up and really get a decision on Speech Now and on the fact that actually so many premises, quite frankly, of Citizens United were flawed. The idea that this couldn't be corrupting, the idea that this would have, quote, that independent expenditures would have little value to the candidates, when in fact what we've seen, as you know, is how candidates are being outspent by outside groups at the state and national level, state Supreme Court races, legislative races, and more. I wonder if you could talk a little bit about, what your thoughts are about this Supreme Court taking up this issue, given some of the other rulings that the Roberts Court has engaged in. I know you're a litigator, so I don't want to put you in a hard position, but can you share your thoughts?
It's a very good question. Look, this Supreme Court, obviously in Citizens United, in our view, got it wrong. But even putting aside how wrong the Citizens United ruling is, they have upheld contribution limits in the past. And that's what this case is going to be about. This is going to not be about independent expenditures as much as super PACs engage in independent expenditures. It's going to be the question of whether unlimited donations to super PACs are corrupting of the political process. And that's where the DC Circuit got it wrong, because they basically said, well, because independent expenditures cannot corrupt, then unlimited donations to PACs cannot corrupt. And there's no equivalence there. There has been a distinction made in the past by the Supreme Court between expenditures and contributions. And we've had for decades prior to the Speech Now ruling, the limits of $5,000 for any entity to contribute to a PAC. And they wiped that out and they said, now, you can have unlimited donations. And now we've seen the way that has fueled corruption and the appearance of corruption in our political process. So that will be the test. And that will be how the argument will go before the Supreme Court, that consistent with their prior rulings upholding contribution limits to prevent corruption, the appearance of corruption, we need to prevent that kind of corruption happening through the super PAC vehicle.
Yeah.
John, maybe one more question before we let you go. And thanks again so much for joining us. But we've talked a bit about the importance of these records in these cases. And of course, in Citizens United, we had this, congressional fact finding that was largely overlooked and wiped away. Obviously, the facts on the ground have changed a lot since Citizens United. There's been a lot of sort of factual counter evidence to the assumptions of Justice Kennedy's opinion there. How is that playing out in this Maine case? I mean, were there legislative findings of fact there that could play into the First Circuit's consideration ultimately, assuming this does get up to the First Circuit and perhaps creates a split that the Supreme Court would review with the other circuits that have upheld Speech Now? How do you see that playing out? Because it seems like this anti-corruption rationale is going to be a really important part of the analysis.
Absolutely. The facts matter. No question about it with this case. This wasn't, of course, a case that occurred via the legislature. This came about because of the ballot initiative. Yeah. So there were no legislative findings. But I will say that I do think there's going to be significant evidence put forward by the Attorney General's Office of Maine on behalf of the state, as well as by Professor Lessig and others. We will be certainly doing it in our amicus brief, demonstrating that the 15 years of facts with respect to the history here of super PACs now in our politics shows the corrupting influence that unlimited donations have. You have people like Bob Menendez, Senator Bob Menendez, who's been indicted and convicted for corruption. And that resulted in part from a super PAC that was engaged, a donor to a super PAC that was engaged in supporting him. That's one example on the Democratic side. There's certainly many examples on the Republican side, starting, frankly, with Elon Musk. But this kind of corruption is completely dangerous to the Republic and to the promise of democracy for all, and is designed specifically for what the court thought is needed in terms of limits. So I think that we have a strong argument to make here, but the facts do matter, and the history of super PACs in the past 15 years will be very much front and center in this case.
Yeah, and you have to wonder whether, as we see this play out, and we see President Musk effectively taking the reins of a administration that seems hell-bent on at least not adhering to Supreme Court decisions, potentially outright defying Supreme Court decisions, something that John Roberts himself in his year-end report seemed highly attuned to the possibility of. If they might find this opportunity to reconsider some of their priors on these questions, before things get truly out of hand to the extent they have not already. John Bonifaz, thank you so much for joining us. Everybody, thank you so much for joining us here on Court Accountability Action with Legal AF. Don't forget to like and subscribe. Check out our Substack. We've been punching out a bunch of good Substack content. That's at Tilted Scales. That's the name of our Substack. And please check out and support John's and his team's incredible work at Free Speech for People. You're really one of the best in the business, and we're so grateful to have you in our orbit. Thanks so much, John.
Thank you, Alex. Thank you, Lisa. So great to be with you. Appreciate it.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.